We're going to talk to now Claudia Revermann. She's going to talk about general estate planning and long-term care planning. This is something that is very, very important. So let's get set and welcome Claudia.
All right, welcome. I hope everyone had a good morning, learning lots of things. I'm excited to take you into the afternoon. I am Claudia Revermann. I'm an attorney and CPA. Our practice is in Waite Park, and Elizabeth Fountain, sitting way back in the corner, is another attorney in our office. We practice primarily with estate planning, real estate, and business law. But today here, I am talking to you about estate planning. Sounds really boring. We're going to talk about death and dying, yeah? All right. First of all, I just want to thank you all for being here, whether you live in the world of assisting caregivers or if you are a caregiver or both. We all wear many, many hats. A couple years ago, my dad was diagnosed with cancer. He has CNS lymphoma. He is treating every month at the hospital with high dose chemo, and so it has been quite a journey. And even though I dealt with all of this with clients for over 20 years, all of a sudden it was a little bit of a slap in the face when you are doing it almost alone. So my parents are 81 years old, my mother has her own health issues, and I'm an only child. And so it was me. So part of the conversations too is, as I deal with other families, is it harder, not that it's a comparison, but I'm going to say, is it harder being an only child doing this? Or is it harder having siblings? Jury's still out. Again, no comparison. There's no winning in this. Anyway, it's tough. And for those who are walking in those shoes, thank you so much for the care. And I'm going to ask you, if you're a caregiver, please write down one thing that you're going to do for yourself, and take that away today, okay? Because I will tell you, when I meet with clients, oftentimes when I'm meeting with the caregiver, that's the question I ask them: what do you do for yourself? And that's when the tears come, okay? Anyway, let's jump into this. I want to make sure this is a bit interactive. Okay, so meaning ask me questions, interrupt. We have enough room where we can do this. We're going to talk about estate planning, and then also if you're still living but you can't handle your own matters and are dealing with incapacity. And sometimes we focus on, with dementia, we focus on the people who have diminished capacity, but we have to remember about ourselves as caregivers that we have to deal with what happens to us as well. All right, so let's talk about wills and trusts and beneficiaries and what all of these things mean. Again, please raise your hand. I'm happy to answer any questions that you might have. Yeah, oh, there we go. I love it, starting right off.
We're going to be buying a house. It's a long story, but I'm debating whether we should put it as a transfer on death to the beneficiaries or as a transfer on death to the trust.
Absolutely. So the question is wondering about buying a home. Are you siblings? Or your family members? Okay, so someone's going to buy a house. Do you put it in the name of a trust? Do you do a transfer on death to the trust? We are going to, we'll talk about the pros and cons of all of that, okay? And hopefully get you an answer, and I will stick around later if you want to talk specifically. Okay, so let's just talk about what does all these things mean: a trust, a transfer, and death, all of that. So think of estate planning in two columns, all right? So on one column, you have probate. Probate, boo. A lot of people hear bad things about it. It's not the end of the world. But probate is a court process that your estate has to go through in order to get everything to where it needs to go when you pass away. All right? So I'll take my husband and I. We have two adult kids. One is 18, and will spend every penny that's in his pocket a second when it reaches it. The other is 23, and he probably has the first dollar ironed out and stuck in a book somewhere, okay? All right, so this is the situation. My husband and I have a house that we own jointly. When the first person dies, when he passes away, I will inherit the house, and because we own it jointly, it just goes to me, and we don't have to go through court. We don't have to do probate. We don't have to do anything. It just goes to me. All right? Same as he has a bank account, and he has me listed as a beneficiary or on his life insurance. Don't anyone tell my husband I'm killing him off before me. I just realized I'm doing this. Yes. Anyway, so he passes away. I inherit that bank account because he had me as a beneficiary. Okay. But what happens when I die? All right, I want everything to go to my kids, and I want it to go equally to them. Well, if I have no plan at all, the state has a plan drawn up for me. And what it says is, because my husband and I have joint children, it's not a blended marriage, if I do die first, everything goes to him, and if not, to our kids in equal shares, or if I'm the second to die or I'm single, everything goes down to my kids. Okay. So that's what the will has, or the state has drawn up for you. But I'm gonna do a will. So I have a will, and the will's gonna appoint my best friend as the executor or personal representative. And it's going to say, I want to give only a third to my younger son because he'll blow it all, and I'm going to give 2/3 to my other son because he's more responsible. I wouldn't do that, but let's just say. And so that will does not avoid the probate process. What the will does is it gives instructions to the court for that house and whatever other assets I might have in my own name to say who's going to be in charge and where does everything go. All right, and so the will, that's probably the number one myth I hear almost every day is, oh, I have a will, I avoid probate. No. You don't avoid probate. You're just giving instructions for the court probate process. All right? So I have a will. It tells the court what to do with my assets. Let's go over to the other lane, the non-probate lane. A few ways to avoid probate. Oh, sorry, I'm going to jump back over this lane. Probate. Court process, here's why people don't like it. It takes longer, usually about 6 to 9 months. It usually costs about $6,000 to $8,000. It's a big ticket item. Attorney fees, court fees, publication fees, those things. And it also is public information. So think about Babe Ruth, famous baseball player. Although he is a public figure, he was very private in his personal life about what he owned and all of those things. Well, he died and had a will. But guess what? It went through probate. Now it's public information and anyone can look up what he had. Again, that's not necessarily everybody's concern, but those are the three things. So the cost, the time, and the public information. Those are the lowlights, maybe, of probate. Not the end of the world, though, because guess what? Whether I had a will or I didn't have a will, everything's still going to go to my kids. Okay. All right, we're jumping back over to this non-probate. How do you avoid all of that court stuff? Well, you can have beneficiaries on everything. So if I have a life insurance policy, I might leave everything to my husband, and if not my husband, then I have backups, and I have my 2 boys on there. Or I could have joint accounts. I do not recommend this, and we'll explain why, but I could have a bank account with both my kids and my husband on it. So whoever survives gets the money in the end. And so back to your question about the TOD. We hear TOD, transfer on death. When you talk about at the bank, they call it a POD, payable on death. Means the same thing. It's setting a beneficiary for wherever your assets, or you want your assets to go. So another way to avoid probate is to set up a trust. Okay, so we've all heard about this thing called a trust. What is it? Think of it like a pail. So it's a pail we set up while you're living, and it does, you'll recall this, what the trust does is it says who's going to be in charge, the person's called the trustee, and where does everything go. Very similar to the will, right? It's very similar, except the trust, because it's set up during your lifetime, says where everything goes and who's going to be there without having to go through probate when you die. But you have a pail that needs to be filled. Because otherwise you could have this really great, nice, fancy pail, but nothing in it, it doesn't do anything. So again, back to your thing, I have a trust, I have this pail, and it says my husband will be in charge if I die, and then I have a backup person, and then I have my two kids inheriting everything. And I bought this new piece of property. Well, if my intention is to have that piece of property go through the same instructions that's in my trust, then I should put the house in the trust. Okay? So your property that you're buying. Is that, yeah? Okay. So you can do that. And that means when you die, then that property that you own or anything you direct into that pail will then be administered by your trustee and go according to your plan. All right, so trust is great. The kind of trust I'm talking about is a revocable trust. That means you can change it, you can add to it, you can take things out of it. It's just an extension of you while you're living. And then when you pass away, it has all of the instructions. The downside of the trust is that it usually costs more money. Okay, so it costs more money to set up, but because you put the investment in trying to avoid the probate, et cetera, and outlining where you want things to go. So yeah, go ahead.
So with the trust, if you were going to put your home in your kid's name, one of your child's names, does it have to be in there 5 years or so? Do you know what I'm trying to say?
I do. So the question is just, I know you're mic'd up, but just to make sure it's clear, if you put your kids on the title of the property, do you have to do that before 5 years, et cetera? So when we talk about this 5 years, what we're really getting at is how do you plan for long-term care or medical assistance planning, okay? Nursing home care, long-term skilled nursing home, okay? And so the federal Medicaid program, what it does is it gives money to states to pay for people's long-term care. And in Minnesota, we call it medical assistance. How do you qualify for medical assistance? Well, if you're single, you have to have all your assets spent down to $3,000 before you would be eligible. And so one of the planning things is to say, if I move all of the assets out to my kids now, wait 5 years before I run out of my money and need long-term care, I would then qualify for medical assistance because I don't have money of my own to pay for my own way. All right? And so the idea is that, and this happens often in our practice, someone comes in and a spouse has an early diagnosis of dementia, and so or it could be Parkinson's, it could be many things, obviously, that is probably a good indicator that a person will need some form of long-term care. And so one of the planning opportunities is to get things out of the spouse or the person's name, put it in the kids' name, so that when the eventuality happens, they won't have enough assets in their own name, and so they will qualify for medical assistance, and then the medical assistance will pay for their care. So let's go back to should you even put it in the kids' names? Is that a good idea? What are the consequences, et cetera? Well, if I'm going to put my home into my kids' names to hold it for an eventual long-term care, skilled nursing care stay, there's a trade-off. Well, first of all, I don't want to have my kids own my home. They could kick me out. No, but they could. Legally speaking, they have to own the home, and I have to cut off all my ties. So just putting the kids on the house with me does no good, okay? You actually have to give up complete control of that asset in order for it to be removed from your assets for application for medical assistance. So another thing is if you put it in the kids' name, let's say you say, okay, fine, I won't have my name on it. I'm okay with losing legal control of the home. I'll put it in the kids' names. Then it is subject to their creditors. It could get hooked up in a divorce if a child was going to be divorced or get a divorce. So there are reasons why you should not put it in the kids' names. Sometimes when I am doing that planning, we will we'll have the kids put it inside of a trust, not the same kind of trust I was talking about that simply avoids probate, but a kind of a trust that the kids actually own and run. Again, you have no ties to this trust, but it protects the assets inside of there so that the creditors can't get at it, et cetera. So it's like almost taking that second step of protection. Does that answer your question, kind of? Okay. Any other questions about that? The medical assistance and the long-term care planning is complex. I mean, it's complex for the attorneys. It's complex certainly for caregivers and the people needing to apply. It's complex for the county to apply the rules.
So what's the 5 years stipulation?
Yep. Okay. So think of a timeline, and I give a gift, doesn't matter, and they have no minimum. This has nothing to do with the estate tax, gifting, so much per year, et cetera. This could be $50 you give to your grandkid at Christmas. Okay, so you give a gift, usually we're talking bigger things like homes or big dollar amounts. They give a gift here, and then we move 5 years. I'm going the right direction for you guys for a timeline, right? It's gonna be opposite for me. Okay, so you wait for 5 years. If 5 years goes by, and then two things happen. One, go into the nursing home or need long-term skilled nursing care. And two, you run out of your money. You get down to that $3,000. Then what happens is you apply with the county to say, hey, I don't have any money left, so can I apply for medical assistance, and then you'll pay for my long-term care. So on the application, they say, tell us about the gifts you've made in the last 5 years. Well, I'm out here beyond 5 years. Let's roll it back. I gave the gift here somewhere. You're clear. The gift you made is completely protected. So that's the 5-year look back. It used to be, 17, 18 years ago, it used to be 3 years. There was talk of moving it to 7 years. It is 5 years. So hang on 1 second. So what happens, the problem is here I am, I gave my gift, fast forward 2 years, I had a stroke or something earlier, I needed long-term care earlier, and I ran out of my money, I don't have any money. You apply for assistance, and the county's gonna say, tell us about the gifts you made in the last 5 years, and they're gonna say, you have to say, well, I gave a gift 2 years ago, and they will say, too bad, we are not going to cover you for assistance. Wow. They don't technically, I think this may be a big misnomer, they don't go to the kids and say, kids, give that money back. They don't do that because they don't have the power over the kids, but they are gonna say, we're not gonna cover you, figure it out. And are the kids gonna figure it out by saying, okay, then move in with us? Or we'll give the gift back and pay for your care for that 5 years until that 5 years runs out. Because once the 5 years runs out, you can go back to the county and say, now I really don't have any money, and then you're free and that money is protected. Did that answer your question? Kind of? It's not an easy thing, yeah. I'm just gonna, oh yeah.
Yeah, in that specific scenario, if there's way beyond 5 years, there was a house put under the trust, the kids, and in the process, the mother becomes with dementia, now placed in assisted living. The house gets sold, and that money that was from the money that was recollected from the house, it's under the trustee from all the kids. That then they can't look and say you got to pay for her care if she comes to the point where she doesn't have any more money.
Was that
is
under
money
5
protected?
years?
More than 5 years.
Way more than 5 years.
Way more than 5
Yep,
years.
you're way out here, way
Yep,
after
yep,
5 years.
That was
It's
done-
completely protected.
Protected.
The houses, or if you
They
turned it
sold
over
it.
to a different house or you cashed it in, it's all protected.
So that money that was sold from the house does not have to be, the county can't say you guys have to pay for this.
Exactly.
Okay,
Yep.
and is that money exempt from capital gains for the kids?
Great question. Let's talk about taxes. I'm a tax nerd, so I'll light up. No. So I'm going to make this, it's not that complex. So capital gains tax. When I own my own home, and I bought it in 1952, And now I sell it today, and I bought it for $50,000 in 1952, and now it's worth $450,000. The difference between those is called capital gain. If my husband and I then sell this house, there is a capital gain, but we don't have to pay taxes on it because it was our primary home for 2 out of the last 5 years. That's great. Or let me give you a different scenario. Bought this house in 1952, and now it's worth $450,000, and we die. We leave the house to our kids. They turn around and they don't like our house, so they're going to just sell it and take the cash. That gain gets wiped away. It's called step up in basis. Not that you have to worry about what it's called, but that basis is your $50,000 you bought it for. It gets stepped up to $450,000, whatever the value is at the time that you died. And they inherit it. They don't have to pay any taxes on it. They get to keep the cash and split it, and they're good to go. Okay. The question is, what if you gave that house to the kids as part of the look back? When you make a gift, that basis, that $50,000, you're also giving that to the kids. So the kids get the house at $450,000. They turn around and sell it the next day and say, you're out, go find somewhere else to live. Or they wait until you die, and then you die and you never needed nursing home care, so you're still in the home. Or you go into the nursing home 2 years from then, and they're like, well, now it's time to sell the house. They will have to pay that capital gains tax between the $50,000 and whatever it's worth when they sell it. Yes, there's the trick. Okay, so the idea is when you make a gift, now if you just bought your house last year, you downsized, you moved into a patio home, and then you're going, oh, let's get that house over to the kids, and it's unlikely we're gonna have much of a gain between now and when I probably will pass away, hey, that might be a good option to do. Or if you just have cash in the bank of $200,000 cash in the bank, cash is cash, right? It's all after tax. You could move that to the kids. But the house creates an issue. Now, we have clients that do have, we'll say, Alzheimer's, and going, this is going to be a long stay. They are healthy as a horse. I think about one of my best friends and her dad. She said, my dad is 6'4", big burly guy, farmer, but he has the brain of, a young child. And so for her mom to manage him was so difficult. And so the idea is we have to plan because his body will take him into a long stay at a nursing home. Okay. So you could consider the capital gains tax situation and go, hey, we get it. The kids are going to have to sell the house. They'll pay capital gains tax. Usually it can vary, but a 15% bill with the IRS and 7% for Minnesota. It's a chunk, so 22%, let's say. But that tax bill is going to be a lot less than an extended stay at the nursing home. So I don't want to say, oh, capital gains tax, don't do it. Nope, we're not going to let the tax tail wag the dog. We're going to make more of a holistic decision on that. Good question.
Okay, back to my question. Right here. Oh, okay. So here we are buying a house. I'm talking about titling the house. I'm not going to title it to the kids. It's my husband and I. He has dementia early still. So we want to know if we should, again, it's whoever dies first, the other guy gets it, and that's all fine. The second person dies, and I want to do a TOD. Do I want to do the TOD to a trust, which I have a trust set up that's already in my own name, or do I want to TOD it to just the two boys outright and not use the trust for the house? Or doesn't it matter?
It doesn't really matter. Here's why, though. So the idea is that if you are doing planning for your husband's eventual care needs, then you may want to disinherit him, which will require changes to your trust, and we can update the trust for something like that. Because otherwise, if you do die first, and I think that's what happens, right? These caregivers, you're going to outlive that person you're caring for. Not necessarily. If you were to pass away before your husband, he gets everything. And not that that's the end of the world, but you might say, well, then he's going to end up in the nursing home and it's going to suck up all the assets and my kids aren't going to get anything. So again, just in that idea of planning for yourself and not giving up on the person that you're caregiving for, but plan for yourself in that eventuality. Okay, so that's one piece of it. The other piece is perhaps you might want, if your idea is just to get it to the kids, you could just simply do a transfer on death deed to the kids and they would inherit that, right? After you're both died, but you have to consider that other spouse's needs. Yeah, good question.
On the 5-year look back, can you give us a couple, 3 examples in your experience of how people screw it up? The most common screw-ups.
I had a law school professor that started out his class, almost every class, and said, I'm going to tell you again, your clients will screw things up. I didn't know that's a thing. Anyway, and it's not that they mess it up, they're just misinformed, right? Or just they heard something, I heard it was this way, or I heard it was that way. On the 5-year look back, well, first of all, I think not understanding what the 5-year look back actually is, because it has evolved over time. Over my career, it used to be the 5-year only, it started way back, like it started when you made the gift, and then it would be assessed an amount that might have expired within the 5 years. Anyway, it's more complex, but now it's a hard 5 years. I think people, the screw up, I hate to say screw ups because I know I'm taking your words, but it's just people do what they don't know, right? And so a lot of times it is the instance of, I just added my kids' names to it. Or another thing is husband and wife, a husband has his assets and a wife has her assets and never the two shall meet. Well, the county doesn't care about that. They don't care that, they just care that you're married. And the one responsibility for a spouse in Minnesota is to pay for your spouse's health care. If a spouse takes out their own credit card and doesn't put you on it, you don't have to pay for that. But if you have medical bills, a spouse is absolutely responsible for that, even though they didn't incur that. That's where all of this, that's if we're looking under the hood about what's going on here, that's the big responsibility. Yeah, it's a snippet of the many things that could go on.
It's been suggested, or my cousin divorced her husband but lived with him because they were afraid that when he went into the nursing home or whatever, and they would garnish some of hers. And if they had separate, then they wouldn't. It would be kind of like what you just said, isn't it?
It is, yeah. So I have done a small amount of divorces for couples who are in a long-term care situation. I have one client who calls it the secret divorce, and she does this every time I see her. I want to come and talk to you about my secret divorce. And when I say secret divorce, it is through the court system, so anyone can look it up. But her kids don't know. She has adult kids. They don't know. They still live together. She cares for him. It's not out of lack of love or any of that or affection. It's purely for separating the assets and separating the liability. I say this like it's a flippant thing. Well, you take your assets, well, I don't mean it's a flippant thing. It's just, divorce and then it's all good. I mean, it takes a lot of consideration. I mentioned that $3,000, that's for a single person. When you are married, you you add up everything. Again, doesn't matter if it's just in his name, just in her name. It's a IRA and there's taxes that need to be paid. Does not matter, put it all in this bucket. Outside of the bucket is a car or a vehicle, one vehicle, and the house. So the idea is the law wants to protect the community, they call it community spouse or the well spouse, the one that doesn't need the care. So the house, the vehicle goes to the well spouse, and also about $148,000. So if you imagine, in our bucket, we have $548,000 plus the house plus the vehicle. The well spouse gets $148,000, and the other $400,000 from the bucket is allocated to the spouse that needs the care. So that other $400,000 has to be spent down to $3,000. Okay? So that drop is what we're really concerned about planning about. What do we do with that? Well, if you're divorced, it could be 50-50. So both spouses will end up with more in the end. But there's other, nuances, et cetera. And I wanted to come back to your question about what do clients do. Probably not understanding what to do with that spend, we call it a spend down, getting from that $400,000 down to $3,000. One thing is you can use it to do a prepaid funeral. Okay? So that's putting money aside. This morning I was somewhere else presenting with a funeral home, talking about this stuff, and also talking about prepaid funeral. So you're basically setting aside and earmarking that money. And I'm not when I say earmarking, it's not, many people have this life insurance policy and go, the kids know that Knights of Columbus policy is just to pay for my funeral. No. It's actually taking those dollars and setting it aside at the funeral home. Okay? And what that does is it's allowed, so it's not a gift, but it does spend down your dollars. You can also spend or prepay for someone's funeral 1 degree from you. Meaning, you could pay for, if you were young, you could pay for your parents' funeral. You could pay for your siblings' funerals. And you can pay for your children's funerals. In addition to you can pay for your children's funerals plus their spouse. So if you said, I'm probably unlikely to have enough money left over, but I want to give some sort of legacy to my kids. I know it sounds kind of out there and wacky, but I could pay for my kids' funeral. I know. But if you think, I probably won't have much left, but at least they'll have 20 grand sitting in a funeral fund so that their family doesn't have to think about it or worry about it. Yeah.
We have a trust, and we also have a financial advisor who wants us to do the TOD for our house deed, and also a POD for our checking accounts. We don't know who to listen to.
Okay, good question. It's all of this POD, TOD, we have this trust, what should we do with it all? So if you have a trust, remember again, aside from long-term care, just pure estate planning for your estate. You have a trust, and it's your bucket that's gonna hold everything. It says who's going to be in charge and where things go. Then you have these other assets hanging out there. The trust is only good to the extent that you're filling your pail, your trust. My recommendation, because I see it on the back end, why it's so important to keep it simple. I have a checking account, I have a house, I have a brokerage account, not a retirement account, but a brokerage account. I have some CDs. And I have my kid named as the trustee. I want that kid to be able to go to the brokerage, go to the bank, and or even life insurance, and dump all of that into the one bucket that I took time and expense to pay for, so that it'll all drop down there. He will use it to pay expenses, and then he'll divvy it up between him and his brother. And so what I'm saying is, my recommendation is always let's stay consistent. Let's not have this account POD, remember that's payable on death, POD to these kids, and then the life insurance, let's do it to these kids, and then this brokerage account, we're gonna do it to the trust. Because what happens when mom and dad pass away is the kids are like, okay, I'm confused. This account, it goes just to me and my brother, but then this one has to flow through the trust. It's not wrong. So when you're saying I'm hearing inconsistent direction, it's not that it's wrong. We always want to make sure it has some beneficiary. The beneficiary might just be the trust, or the beneficiary might be the kids. But we want to make sure everything has beneficiaries one way or another. And it's better to have it all going in one place. I'm going to throw an exception out, which this might be some of the confusion of like, well, I'm hearing all kinds of different things. When you have IRAs, 401ks, annuities, things that have taxes that are due when you pass away, you do not want to name that trust as the beneficiary of that IRA, because if you do, all of the taxes that are built in there will be due as soon as you die. Could be a big bill. Rather, we would like to have the kids, and I'm using a really, maybe, I don't know if it's common, but very basic example. You have some kids, right? Mom and dad die and you have kids. Name the kids as the beneficiaries, because the kids then have 10 years to be able to take out that money. If you slow down the time that you're taking the money, you slow down the taxes too. Yeah.
On the TOD, do you, the capital gains, how does that, are they affected? Do they have to pay capital gains if it's a TOD?
Let's talk just a bit about taxes, because we'll cover that. So we each in Minnesota have $3 million we can pass down without paying any estate tax. So you hear income tax, capital gains tax, inheritance tax, gift tax, lots of tax stuff, right? Keeps me employed. But if you have a TOD, a transfer on death, or a beneficiary designation, that person that inherits does not pay any taxes. They do not pay capital gains tax. They do not pay estate tax. There might be, if it was a retirement account, as we talked about, they'll have to pay the income tax, just like you guys, when you're taking things out of your retirement accounts, you have to pay income tax. As long as your estate is under $3 million. In Minnesota, a married couple gets $6 million. You each get $3 million. Anything over that gets about a 16% haircut. Okay, so if you have $4 million when you die, $1 million of it's going to be taxed. Now the federal government allows, it's just short of $13 million per person. So a married couple could pass $26 million down without paying any federal estate tax. It's a big number. January 2026, it's likely that that's going to come down to about 5 or 6 million. So a married couple, 10 to 12 million.
So if there is such a thing that we've been talking about is a revocable trust, what does an irrevocable trust look like, and why is that not good?
Not good. Yeah, it sounds irrevocable, right? Okay, so we've been talking about the revocable trust, where you can change it, you can add to it. It's just an extension of you. An irrevocable trust is not revocable, meaning you can't change it. So once you put that stuff in there, you're locking it in. I would say most times we're using irrevocable trusts, ones you can't change, have to do with estate tax planning. Okay, so I'll give you a good example. Let's say I'm worth $20 million. Okay, I am not. Thanks, Molly. Right, just my smile alone. No. Let's say I'm worth $20 million, and I have a $5 million life insurance policy on top of that, because I know I'm going to have to pay some taxes. Well, if I die and I have no planning, I have $25 million that will be taxed. Okay, so sometimes what we do is we take that $5 million policy and we put it into an irrevocable life insurance trust. Have you ever heard ILIT? Not that you should, but ILIT, we have all of these little, But anyway, so an ILIT, and the irrevocable life insurance trust is now the owner of that life insurance policy. So what happens is that now I don't own it anymore. It's on my life, but I don't own it anymore. My husband can be be the trustee, the boss of it, and he can be the beneficiary of it. But what that does is by placing it in there, now I'm not the owner anymore. And so when I die, my estate's only worth 20 million, not 25 million. So that's a technique to get things out of an estate. Let me speak, because we were talking a lot about medical assistants and nursing home. And we hear this irrevocable trust. Sometimes people have irrevocable trusts. Having an irrevocable trust in Minnesota since 2005 is no longer allowed. Okay? If you had one before that, it's still okay. But you cannot have an irrevocable trust, because sometimes people, what they were doing is they were putting their cabin in an irrevocable trust. They could still live there, use it, all of those kinds of things. When they died, it would go to the kids, but if they needed nursing home care, it wouldn't be counted in their assets. Kind of a nice technique. Well, that loophole was closed. Okay, so that no longer works. But rather, when I talk about, hey, instead of giving it to the kids, give it to the kids and then the kids create a trust, that trust that the kids create is revocable. The kids could change it. Likely, we're going to say it takes all of the kids to change it. So it might be a tough feat, almost like it is irrevocable, but it is technically revocable. They could change it. My gift to the kids is irrevocable, meaning when you give a gift, if I give Dr. Zook $50, and then I go, ooh, I'd like it back, please, he has control of that, and he can just take it. It's irrevocable. My gift to him was irrevocable. So oftentimes what I hear is those things kind of get crossed, right? That irrevocable, revocable. But did that answer your question? Yeah, okay. Probably more than you wanted to know. We're making sin run.
So you talked about gifts to kids. What if you give gifts, large gifts to charities or your church or something like that? Does that then disqualify you for MA?
So gifts, there is no minimum and there's no exception for charities, okay? And so if you, I should say but, if you give $50 every week in the collection, that will be accepted out as long as it's shown as a pattern of giving. Okay, and maybe you every year in December you go, I give $1,000 to pick my favorite charity, and I spread it around. That will be accepted. So basically, what happens when you do this application is you apply, and it says, tell us about the gifts you made in the last 5 years, and you're going, I gave to charities. I doubt it counts, or I gave $50 to my grandkids for their birthday. It doesn't count. The financial worker. Do we have any financial workers in here? With the county? Okay, and I'm not saying that I'm gonna say any secret things, but, sometimes I talk and then there's a financial worker. They have a really hard job. There is a manual this size, and every county does it just a little different, and then every worker inside of the county does it just a little different. So it's a crazy world, but you apply for assistance, you said, no, I didn't give any gifts, they will, or they have the right to ask for your bank statements for the last 5 years. You give that to them, they'll pour through that and go, hey, what was this? December 24th, you wrote all these checks. So, yeah, it's sticky.
What about gifts to like a 529 for your grandkids?
Still a gift. Anytime you're giving something away, that you're not getting something in return. Okay, so I give Dr. Zook $50, and I said, but ask me back next year. I got something in return, right? No, I'm not asking. I mean, I would love to come talk again, but something, or I pay the person to mow my lawn. It could make my kid or my grandson, etc., right? That I'm getting something in return. But it's any time you're giving something where you're not getting anything back, and not just love and admiration from your grandchild for paying for their education.
Okay, I'm on my way, but I have a quick question
Yeah.
as while I'm stalling. When you mentioned the IRA, are you talking about regular and Roth?
So Roth IRAs, they don't have any taxes that are due when you take it out. It grew tax-free.
Okay.
So they still have to, the children would still have to take, if you, or your beneficiary has to take it out over 10 years still, even though it's a Roth. But they could all take it, or they could take it all out in year 1. They could wait till year 10 and take it out. There's no taxes due, as opposed to a traditional IRA.
I just went through the process to qualify my dad and stepmom for Medicaid through the county, and it took about 9 months to get that done. And they had everything in a trust, and now everything is gone from that trust. Does it automatically dissolve, or do you have to legally dissolve it?
Ooh, great question. So if we think of that trust like a pail, now we've plucked everything out of that pail. The pail can just be thrown aside. You don't have to do anything. Yeah. And if someone tells you you have to do something, don't pay anybody to do something like that. No.
Oh, so I just have a quick question. So if do have a trust and it's for my kids to get our home, do I still need to do a will and have all that information in the will? Or does the trust automatically take care of that for my property?
So whenever I draft trust, you should also have a will. But the will is short and simple. All it says is if I miss something. So I bought a cabin. I totally forgot I had this trust. I didn't get that cabin inside of the trust. I died. Now that will catch it. It still has to go through probate. But it will catch it, and then the will names the trust as the beneficiary. So it just scoops it up. We call it pour over will, meaning it's going to pour it back over into the trust so that it will catch it. I think we might have just a couple minutes, so.
My husband has Alzheimer's, and I've been told he can't drop a will because he's not mentally capable of making a decision on that. So we're kind of in limbo with our finances and home, and because they won't accept his decisions.
Got it. So, I know Chris was here from Legal Aid, and she was talking about healthcare directives and powers of attorney, and part of that is, having somebody be able to sign for you. One thing, a power of attorney, which is allowing someone to make financial decisions for you if you can't do it on your own, that does not give you the ability to do a will for anyone. I do estate planning for people who have dementia-type illnesses, because the legal standard for making decisions is different than the medical standard. And when I say that, I'm not just handing them out like candy, like we can do this. It's not that. Rather, people can have moments of lucidity. I need to have a conversation with that person separate from anyone else. I would have you not in the room, and I would determine whether your husband knows who's in his family and knows what he owns, and also knows what he wants to do if he passes away with that. He could remember that in the morning, but sunset, afternoon, no idea. Not remember that he signed it, but it's okay because in that moment he was okay. Okay? Now, that's on me too, that I'm not doing something. I have my own law license that I like the scarf you're wearing, but I'm not going to risk my law license, right? So I'm having a good conversation with him about it. But I would say I would be curious to know more in your situation, because a will might not do it, because it all depends. If you own that home with him and he dies first, it's going to go to you anyway. Yeah. It's more preparing that second, like we're talking about, if you die first, right? What happens? But know that the state has a will drawn up for you. And you might think, okay, it's fine, it'll do. So he doesn't need to have that will. So if you did die first and then he dies, maybe it goes, I don't know if your family situation, but I have 2 kids. It's going to go to the 2 kids. It's not exactly how I had planned, but it's going to get there, and it'll be fine.
One more question here.
Wills and trusts, if they're under 18, or maybe you have 3 kids, one's 18, the others are younger, how does that work for those that are not adults?
So even my kids, I don't want them to get my assets right away when I die. Okay? Because there's just maturity there, et cetera. So even if they're younger. So what you could do in a will, and you can do it in a trust. So don't think you have to pick one or the other, but you can set up a trust inside of the will, or use the trust to say, you know what, they can have a third at age 25, at 30, they can have half of the rest, and then at 35, they can have whatever's left. Up until those ages, they can have the money for education, general support, health issues, and your trustee is then in charge of giving them money as they need it. Yeah. Thank you, everyone. This has been such a joy. Thank you.
Thank you, Claudia Revermann. Wow, we had a lot of good questions, and you probably could have gone on for a lot longer.